Commercial Hotel at Makini. Criminal case number UPF-040 of 2024. Uganda versus A1RO1274 Captain James Fowler, A2RO3098, Colonel Dr. Chiza MSG, A3 Hajj Obed Vitali. Ruling of the court and the objection raised to amend the charge sheet. On 13th January 2025, Colonel Raphael Counsel for the state applied to amend the charge sheet by adding Captain Dennis Ora as the third accused person and application was allowed. When it came to pre-taking, Counsel for Colonel Dr. Chiza Lisa, led by Martha Kalua, Yas Lukwago, and Ernest Kalibara, raised the following objections in the bar of his trial before this court. That this court has no territorial jurisdiction in entertaining charges that were already committed outside Uganda. That the charge sheet was defective because it was not in accordance with the BBS Act by mentioning defense forces. That is not clear as to which defense forces were being referred to. That how the accused persons, but that how the accused person was brought before the court did not follow the due process of the law. Our counsel cited this court, the case of Omar Awad Omar and 10 others versus Attorney General Consolidated Constitutional Petition number 55 and 56 of 2011, and submitted that the accused person was illegally brought here from Kenya to Uganda, having been abducted. That section 208 and 209 of the BBS Act that appears to grant the court jurisdiction contravenes Articles 79 and 129 of the Constitution. Counsel read that this court finds the guilty in the objection and discharged the accused person. In reply, Counsel Raphael Mutsha for the state submitted that jurisdiction is a creature of the statute, and therefore section 208 of the UPF Act gives jurisdiction to this court to try the accused person. Our counsel further submitted that the words defense forces are defined in the UPF Act to mean Uganda People's Defense Forces, and therefore the submissions of counsel to the accused are misconceived and should be ignored by this court. Our counsel further submitted that section 117G on aiding and abetting and H on being found in an unlawful possession of arms or ammunition brings the accused person before the jurisdiction of this court. Counsel further submitted that the accused person was brought lawfully through the memorandum of understanding between Kenya and Uganda on interstate arrangement on defense and security for offenders involved in committing or suspected to have committed serious crimes like terrorism, among others. Our counsel further submitted that the constitutional provisions cited in this matter are not applicable. That is Article 23, 28, Clause 7, 12, 126, 129, and 79. Counsel further submitted that there is no decrease in the charge sheet as alleged. In the remainder, counsel for the accused submitted that in the case of Omar Awad Omar, the Tanzanian case of Mataka versus R was distinguished. counsel submitted that in a number of cases cited, no matter what, above where there is evidence of abduction, then the court has no jurisdiction to try the accused person. Lastly, counsel retaliated earlier prayers that the court finds merit in the objection raised and discharges the accused person. This court, after listening to the submissions of both counsel for the accused and the state, considered the relevant laws relating to this application as deliberated on this application and finds as follows. One, that jurisdiction is a creature of statute, and section 208 of the BBS Act gives powers to this court to try any person who has committed an offense in Uganda and outside Uganda. Two, that there is no defect in the charge sheet because the accused is charged under Ugandan law. Under Ugandan law, the UPDF Act, which Act clearly defines defense forces to mean Ugandan People's Defense Forces. Three, on the submissions that the accused person was abducted and brought to Uganda without following the due process of the law, this court finds that there is no extradition treaty between Uganda and Kenya that was breached. To the contrary, this court finds that the accused being brought to Uganda through a memorandum of understanding between Uganda and Kenya on defense and security for persons suspected to have committed serious crimes did not amount to abduction. This court has considered the consolidations of the Constitutional Court in Omar, and others which were cited by the counsel for the accused from paragraph 25 on page 63 to page 74 of the judgment, and entirely agrees with the court. For on the submission that section 208 and 209 of the BBS Act that appears to grant this court jurisdiction contravenes Articles 79 and 129 of the Constitution, this court finds that it is not true that section 208 of the BBS Act appears to grant jurisdiction, but actually gives jurisdiction to this court to try the accused person. Jurisdiction being a breach of the statute, and this court having addressed itself to the provision of Article 79 and 129 of the Constitution. This court finds the cited articles not applicable in this application and finds that this court has jurisdiction in the case. Accordingly, the objection raised are hereby dismissed and the accused person should take plea. We saw rule done at Makinde this 14th day of Jan 2025 under my hand and seal of this court.